This is just a general overview of the actual bill. We have made the bill public by putting it on our website. So for those of you who has any questions as far as any of the sections in the bill that you have seen and they have questions, then please do feel free to ask them. But we ask that you save the questions for after the presentation. So just looking a bit into the contents of what this presentation would have. Firstly, just a short introduction into the Computer Crimes Bill, as well as the Consequential Amendments, the jurisdiction of the bill, just a slight summary of the bills. And we really want to highlight to you guys the offenses, the new offenses that this bill brings, as well as some of the consequential amendments. There are new offenses in there as well. So we will show you also the penalty ranges, as far as what are the punishments for these offenses. We'd also like to just touch base on generally on the police powers, as well as the service provider capabilities, and also the protection and penalties for service providers. Also, just to ensure the public of the safeguards that are in place with these laws. And just looking at as far as the way forward or the implementation plan in a general concept. So like I mentioned, we're here to introduce the new Computer Crimes Bill and its consequential amendments of 2019. Now as you can see, it's a new Computer Crimes Bill. There is a current Computer Crimes Act, but at the moment that is from 2003. It is very outdated. As technology progresses, our laws has to progress as well. Because with the progression of technology, so is how crime is committed and facilitated. And at the moment, our Computer Crimes Act is not sufficient enough to be able to capture all these new crimes that are coming into play. Things on social media and stuff, it's very vague in our Computer Crimes Act, the current one. So with this new one, is to address all those problems. Also, what consequential amendments are when this bill is made or when it's enacted, then it makes other laws, it affects other laws. So those have to change as well so that it runs together, so that it doesn't contradict each other. So that's a list of the consequential amendments, and we'll get back to those later on in the presentation. As I mentioned, the current law is the Computer Crimes Act of 2003. That is about 16 years ago. So very outdated. This is in the time of MySpace and Bebo. Also, I'd like to note that Tonga had became a party to the Council of Europe's Convention on Cybercrime in 2017. Now, I'd like to mention that Tonga is very proud to be the very first in the Pacific to be party to this convention. This convention, though, however, it allows us to access other law enforcements internationally and other organizations in assisting Tonga. Because with cybercrime, there is no borders as far as the criminals are concerned. However, with the laws, there are borders because each country is sovereign. But then when we join such conventions like this, it eases asking assistance and seeking assistance from not only international states, but international organizations. Also, being part of this convention and being able to tap into those resources into foreign states and international organizations. We must align our laws to be at an international standard, because then we'll be the same with every other single party state. We cannot seek their help unless we have the laws in place to be able to seek their assistance. But at vice versa, they have the right to also seek our help. So that's why these laws have to be made, to be able to make this connection, as well as it will assist us as a country in the fight against cybercrime. So with that being said, Tonga needs to update its laws and fulfill its obligations to the convention. At the moment, there are other countries in the Pacific who are also making way to making the same laws that we're making. But Tonga did start it. If I can just summarize the bills that I was talking about. With the Computer Crimes Bill 2019, it provides for the prevention, the investigation, suppression, and imposition of penalties of computer-related offenses in Tonga and for related purposes. The Copyright Amendment Bill 2019, it criminalizes using a computer system to infringe rights under the Copyright Act 2002. Now what this means is there is already existing offenses in the Copyright Bill, in the Copyright Act, sorry. What we're doing is adding the computer element to it. Because with copyright infringements, a lot of it can be done using a computer system. So the current act did not cover that. So what we're looking for is to add that in so that it captures that as well. The Criminal Offenses Bill, it criminalizes and sanctions new offenses regarding child abuse. It also captures traditional offenses being committed or facilitated by means of a computer system. Now at the moment, our laws, there are loopholes on it as far as things that are done on social media or social media platforms. However, especially with child abuse or child pornography, we don't really have anything at the moment. So with this new bill, with the Computer Crimes Bill, it opens it up and allows us also to make changes to the Criminal Offenses Act. As I said, with traditional crimes, basically just adding in the cyber element, facilitating traditional crimes through the computer. There's also other amendments to the interpretation. So this just inserts definition of document to also include electronic records and the definition of person to include a body, corporate, unincorporated body, or an individual. Again, the change to it is just to also add in the electronic element to it. Tonga Police, this allows the police to seize a computer system or data storage medium found on any person whom police have searched without a warrant. So currently in the Tonga Police Act, there are already provisions there for the police to execute a search without a warrant. There are already safeguards in place as well. However, they also have a list of what they can seize, but the current one did not have that they can seize a computer system or a data storage system. So that's why there was a need to make an amendment to the Tonga Police. Also, we added the words and definition of computer system and data storage medium. Now, it may be helpful if I mention that computer system doesn't necessarily mean just a computer. It could be your tablet, it could be your phone, and data storage media is basically your flash or anything that can store data on it. Now, if we can move on to the jurisdictions. So, as you see, criminal charges can only be laid against persons if the act or the omission, firstly, is committed in Tonga, committed on board a ship or aircraft registered in Tonga, committed by a person who is in Tonga, it's committed by a subject of Tonga who is a resident in Tonga, committed by a citizen of any country who is ordinarily resident in Tonga. The jurisdiction also goes to any acts or omissions done in order to compel the government of Tonga to do or abstain from doing any act, or is committed against a subject of Tonga, is committed by a person who is, after the commission of the offense, present here in Tonga, or is intended to be committed in Tonga, or either originates in or transits in Tonga. So basically, this jurisdiction allows us to widen the scope of the bill and who can be held accountable. As I mentioned before, cybercrime is borderless, and we try our best to try and capture and protect the Tongan people, Tonga as a country, with these laws. So as you can see, there are some there that shows that the person who's actually committing the offense may not be in Tonga, but it's committed against the subject of Tonga. So I mean, this law will also extend, that person can be held liable for if what he said or did amounts to a criminal offense under Tongan law. And again, this goes back to the international framework. Because we have these laws in place, because we are party to this convention, other states, if the person is in that place, it'll be much easier to prosecute that person, maybe to even extradite him here. So if we have these laws in place, we can really protect Tongans, whether they're here in Tonga or abroad, or whether the person committing the offense is here in Tonga or abroad. They will be held liable under these laws. So this is just a general overview of the offenses. I know my colleague Dubo was passing out sheets to you guys. I think that goes more in depth into what the offenses are, but this is just a general overview of it. So we have computer offenses. Now these computer offenses are offenses that are actually done using or through the computer. This is like hacking and unauthorized access to a computer system. So as you can see, we have out there the lowest penalties, the highest penalties for individuals, but we also have penalties for corporations, for companies. So these are the fines as far as the lowest and the highest, and imprisonment time, or both. And as you can see, child abuse offenses, the highest penalty, is 25 years. In Tonga, after murder, which is life, then the next highest is a drug offense, and then manslaughter, which is also 25. So this is up there in the range as far as the seriousness of offending. It's bad enough that child abuse happens, but then if you use a computer to share my money or go live with it, that's held to be even more worse. So the offenses created under the bill includes these, but they're not limited to these. There are more. But we know that people have been asking about whether this new law will cover these offenses that we have in place. So the offenses will cover revenge porn, online bullying, harassing a person via text message, making threats on Facebook, and child abuse. And at the moment, with these laws, there are certain powers that the police will have as far as investigation. I'm pretty sure you guys are all aware with social media, something can be posted 1 minute and taken down the next day. But if it's a criminal offense, the police do have the power under this bill to go to a service provider and ask, can you preserve this information? So even if that person deletes it from their page, it's already been preserved. Because whether he took it down already, the whole point is you have put it up. You have committed the offense. For that one whole day, how many people have seen it? How many people have shared it? How many people have downloaded it? Perfect example is the Christchurch incident. I was in Japan at the moment when this happened. As soon as it happened, it was taken down maybe in a couple of hours. Half of the people I was with already downloaded it. So they had copies of it. So it doesn't matter whether it's already been taken down, but the fact that it was uploaded in the first place is the offense. And with this new bill, it gives the powers to the police to be able to go to the service provider and say, we think this is an offense. Can you please hold on to this this post, this information, this data? But at the same time, there are safeguards in there to ensure that access no ia hataha to those. The police can preserve it, but they can't access it yet. That's a whole different warrant. Because at the same time, this bill really does look at the human rights as far as the right to privacy. And the more that we intrude into people's privacy, the higher the authority that the police has to go to gain access. There are considerations in place in this bill, which things has to be considered before they're allowed to do so. Considered by the police, considered by the commissioner, police commissioner. There are some that has to be considered by the Attorney General. And there are some that has to be considered by the Supreme Court. At the moment, a lot of the warrants are just done at magistrates. Not anymore with this bill, because we're really going into people's privacies, into their private lives. What are they sending on emails? What are they sending through Facebook Messenger? People have a right to privacy as well. That's why these safeguards are in this law, to protect that right. And before the police can even access these, what we call content data, they have to go to the judge, and the judge has to outweigh the public right, the public interest. Is it in the public's interest for this information to be given to the police? And also, weigh out the right to privacy. Is that person's privacy outweighs the law of justice? So these are things that are in place to safeguard those things. I mean, though we may preserve the data, that doesn't mean that we can access it automatically. There are different junctions or different steps that must be taken first before we can even take a look at what's in it. So basically that was my point with that I was talking about. It strengthens the investigation powers of the police in searching and seizing and dealing with electronic evidence. Now at the moment, under the Magistrates Act, the search warrant is very general. Basically, the police can just go get anything. Because there's always a part at the end that says, and anything else that may have to do with the crime. So that's the umbrella, that's the catch-all. However, with this bill and what it actually allows the police to do, we look at it that it's intruding more into people's privacy. And there should be safeguards there to ensure that this power is not abused and that people's privacies aren't infringed for unlawful purposes, unlawful reasons. So for example, no longer can someone whose daughter has a new boyfriend that you may not like. I mean, technically what you can do, you can practically find out who this person is, the whole background, who's he talking to, the content of what he's talking to. But with these laws in place and protections and safeguards, you can't do that. It has to be for a lawful purpose. So what we want to ensure the people is that though the police have this power, it's protected as well. That it has to be legal and there has to be things that are met, requirements that are met before they even get access to it. And as I was talking before, as far as online and going to a service provider to ask them to preserve certain things, they are a very key stakeholder in this bill. They have obligations here, and it's basically because they are the gatekeepers of the data. If people go through either using TCC or Digicel, and things that may come into the country and received by someone here would be someone who is using TCC or Digicel. So that's why we say that they are the gatekeepers of data. And as I mentioned before, under these laws, they are obliged to preserve data, as well as disclose data when receiving requests or orders from the police. However, there are protections. And those are the protections that I was talking about before, as far as there are safeguards there for the police not to just use their powers anyhow, but also there are protections there for the service providers themselves, because then they also have an obligation to their customers, to their subscribers. However, this law also allows the service providers to disclose, preserve data to the police without having to worry about any liabilities against them, as long as it's done in good faith. In good faith and it's reasonable, which means that it's for a lawful purpose only. Service providers must also ensure that their networks and facilities aren't being used for the commission of an offense. service providers don't only mean TCC and Digicel. It also covers Facebook, Twitter, WhatsApp, Gmail. So under this law, Facebook and Twitter will also have to comply with what we have in place. So as far as this point is concerned, this means that when a service provider becomes aware, such as this, sorry if I keep mentioning it, but the Christchurch incident. Once Facebook is aware, they have an obligation to ensure that their platform is not being used to the commission of an offense. Also, under this bill, the service providers must assist as best as they can and in a reasonable form to the Tonga police. If you would have time later on to it and you go through the bill, you will see everything that I'm talking about as far as the obligations of the service providers and how they deal with the police. So there's also the protections that I was talking about. They have to do their best as far as making sure that their facilities and their platform is not being used to commission an offense, as well as provide reasonable assistance. And it's also, as I mentioned before, if they do this, they will not be liable for damages, acts done or omitted in good faith. There are penalties also in place though for the service providers. This is going towards the breach of confidentiality, as far as if you are served an order or a notice by the police to preserve something, that something preserved was from someone. So that someone can be said, that's the suspect. So you gotta keep that confidence. You gotta keep it confidential. You can't go to that person because that person's your neighbor's son or something like that and tell them, hey, the police came, for some reason they wanted us to preserve this. You know, because then they're gonna try and go and delete everything else or whatever. But then again, because the police had already preserved the data, they may have deleted it from their platform, but we have already a copy of it. And also just failure to comply with domestic and international obligations. As I mentioned before, service providers and this bill and Tonga as a state, we don't only have an obligation domestically here in Tonga, we also have an obligation internationally because of being party to this convention. This slide here talks more about the safeguards that I was talking about. The right to privacy versus the interest of justice. There's a high threshold in accessing content data. That's what I was talking about before. The police can go and preserve data, but they can't access it. They had to go through the Supreme Court to get a warrant to be able to access what was preserved. So one of the key considerations in that is there is public interest in accessing the records, and it substantially outweighs the right to privacy of a person whose privacy may be affected as a result of that access. Also, the next point, investigators exercise reasonable care not to damage. Previously, when I was talking about search warrants, it allows the police to search and seize electronic evidence. This included computer systems, data storage mediums, as I mentioned before. So the investigators had to exercise reasonable care not to damage those properties, because at the end of the day, that property at that time still belongs to the individual, even though he's a suspect. He is still the owner of that property. So the investigator must take reasonable care not to damage them. Also, they have a duty of care to return these computer systems, return the storage medium when the investigation is done. There are times though that the police do have the power not to return. And it's whether they think that if they do return the computer system or the data storage medium, will this person continue offending? He may go buy another computer, that's on him. But the police have to consider whether them handing him back the computer, will he just continue offending if they hand it back? So there is provisions there that they had to return these things. However, there's things that they can consider as well as far as returning. And though it may sound unfair to some, but if you think about it, if this person is a child abuser, a pedophile who uses the internet to do such things, that's what I'm talking about. As far as the consideration. Is it safe for the public? Is it safe for the children of Tonga to return this to him and to allow him to continue? I believe this is the last slide. Just looking at the implementation plan, it's just there is an implementation plan in place, and it's basically just steps involved as far as the relevant stakeholders and what needs to be done from now on as far as to implement these new bills. It is the responsibilities of the stakeholders for further training in all aspects. It is not only the police as far as the investigation. It's not only the prosecutors as far as prosecuting these cases. It's not only the judiciary as far as the judges and the magistrates. But there also has to be a wide awareness as far as the people themselves to understand these new laws that are coming into play, which is the last one as far as community awareness. Cybercrime is a very new thing here in Tonga. These laws are very new. There has not been much prosecution as far as cybercrime. It is a long way to go before we are comfortable, but we are progressing, we're getting there. And at the same time, we need to hurry and be there because the criminals have left us way behind. Because they don't have any laws they have to follow. They have no borders to worry about. We do. But again, as I stressed, that's why this bill is important, because it'll allow us to fight back. It'll allow us to catch up. So then with this, we'll also develop procedures and policies, boost our technical capabilities, and just raise the awareness with the community as a whole. That's all I this morning, and we'll be more than happy to take any questions. Though I'll be sitting in the front here, I also have a colleague with me who can also assist. As I mentioned, I have with me Peter and Catherine, our consultants. They have been with us since the beginning of this, and they are the experts in this field, and they'll be of great assistance. So if you want to direct anything to me or to them, feel free to. You also have to go back on here. So I open it to the floor. Any questions?
Sorry, I put a mic on there. Yeah, you were saying before when you started, you talk about traditional crimes. What are traditional crimes?
Yes. Thank you for the question. Traditional crimes is what I mean is what's existing now. As we see theft, right now, at the moment, we do not cover it when it is done over a computer or using a computer and facilitating those stolen goods as far as the property is concerned. So it's basically adding in the cyber element into those crimes. At the moment, we also, yes, I think Catherine would like to add on.
I think so. I just wanted to add that what these powers are doing, what these new offences are doing, is addressing all of the new type of crime rather than what the old crime is. The reality is that platforms which allow people to do anything, any time of day, instantaneously. You can bully in the privacy of your bedroom. In the past, children who went to school got bullied at school, and at least when they got home, they had freedom and away from that. The reality of modern crimes that happen completely online is that they are insidious. They happen without other people really knowing. You know, you could think it's the nicest person, or the reality is that child abuse is rampant around the world, and what the internet has done is it's allowed people to have forums. You know, there's the dark web, we haven't talked about any of that sort of thing, but there are places where people who choose to abuse children can go online and they can groom children. They don't care where those children are. They could be here, they could be Fiji, they could be in Canberra, where I come from. But the internet allows them to do that. I mean, historically, you know, if you see someone walking down the street with, you know, looks like bulges of cash in their pocket or drugs, the police can sort of stop them and see that. But the reality is if they're actually selling the stuff through text messages and will meet you, you know, at the corner of outside this, you know, restaurant, that sort of thing, the only way you're going to get access to that information is through the use of new powers. And I think Tonga, and I say this proudly, having worked with Tonga for a couple of years now, is the first in the Pacific to stand up and take on these new powers. In Australia, we're fortunate that we've had these powers for a while, and we acceded to the convention, I think, in 2013. But even when we acceded, we didn't have all the offences, so they are in place now. So I think the reality is that there might be certain crimes, you know, that happen offline, but even those will have an online element. If you think about if a group of people have murdered someone, they might talk on the phone, and so this will allow the police to actually potentially intercept their calls and actually get decent evidence that they may not have got otherwise. Thanks a lot.
Joshua, you would like to ask a question?
I would like to talk more about because you said there's penalties for corporations, so the internet service providers, right? So there's new companies will have penalties. Penalties for what? I want to know like what offenses are they? And are you charging the corporation as a whole or just one person in the corporation? So what are the So say for example if it was just an individual citizen that was committing crime, then you can charge the offense. But I I was wondering about the corporation part. I wasn't too sure.
There's a couple of aspects and we're not going to take over. One is if there is an interception warrant being executed on a carrier and a person who works on the carrier's network goes, oh, that's cousin Phil. It happens everywhere. It's happened with us in Australia many times where they turn around and go, oh, best give him a tip-off that the police are doing it. So there is actually an offence if you don't obtain the confidentiality of that. Now, the confidentiality is probably one of the most significant accountability requirements when it comes to the execution of those documents. However, once, and it's not going to happen overnight, but service providers can assist to the extent that the laws may require. But once, and that's a matter for government to decide whether they have to be able to fully comply with it. But there will be, there will be an offence if they refuse to assist. And then that will be more a corporation type offence. Whereas if someone has breached someone's confidentiality, that's an individual. So people who are doing their best obviously work in an organisation, but they're bored of governments might say, oh, we don't want to. And I mean, it's not unusual, it happens everywhere in the world because it costs money. But we're hoping in Tonga that the cooperation between police and service providers and government departments is such that they'll all work together towards having this, so there won't be any need for that sort of thing.
So, because I was wondering about the Christchurch shooting.
Yeah.
The guy, he uploaded on Facebook.
Yeah.
Was any of the internet service providers in New Zealand charged for any offense for providing that service?
What appears to have happened so far is that it's Facebook. It was on Facebook. It was uploaded on Facebook and live streamed. You've had a reaction in Australia, and they've made that it's an offence, a criminal offence, if the service provider doesn't remove abhorrent material in a short period of time. We've had publicity in the UK. They're talking about not allowing live streaming at all in the UK. New Zealand seem to be still working out exactly the purpose of the governments and things like that. That's what it'll do. But the actual service providers who sit at the base and facilitate access to it are not the ones who can take it down. They're not the ones who even may have any visibility of the material that's on it. So the importance of this legislation is that it opens the door to talk to service providers who are not based in Tonga and work with them and have MOUs for how they can cooperate on these sort of things. But obviously this bill was written before the Christchurch massacre, but it's very clear to the Attorney General's office that they need to be working with the Facebook and others to protect citizens of Tonga and protect this sort of thing from happening. So, so it's on the agenda, I suppose, is the reality of it.
Thank you.
In the Communications Act 2015, internet service providers are required by law to report on child pornography as soon as they have become aware of it. Yet is there a way that you can ensure that these reports do go through to Tonga police?
Yes, as Captain had mentioned, as well as in the presentation, it shows that they have to do their best to make sure that their platforms and their facilities aren't being used to facilitate these things. It's an obligation that they have to fulfill. So the law does say that they have to, once they're aware of it, report it to the police.
So there's no penalty for an offense for not reporting? Is there?
I believe if I go back to the penalty slide. So this may come under the failure to comply with their obligations domestically and internationally. There's provisions in there So that can come under that. If you guys have any other further questions, you won't have to take them. But if not, you can always email us or contact us at the Attorney General's office, our social media platform. If you have any further questions or comments on this, we're more than happy to hear them out. If there are no further questions, I just would like to, on behalf of the Acting Attorney General, thank all of you for your presence here today. It means a lot to us. This bill has been in the works for the past 2.5 years, I believe. And I had just joined halfway through, but people had been working on this. People have recognized that these are serious matters that Tonga needs to address, and also to protect our people, to have these laws in place. And this can only come through having this law in place and having the relationship with our domestic stakeholders, the regulators, the police, the prosecutors, and the service providers, and everybody on board. But not only that, to also be on board with our international partners, as far as co-parties in the convention and other organizations that this law will allow us to tap into. So, with that being said, I'd like to thank you all